Used for quite some time in labor management and other disputes, it is a relatively new method to resolve, for example, commercial, construction, or insurance disputes. As such, the practice has been that if mediation is discussed at all, it is only after a dispute has arisen. Since mediation is a consensual, non-binding process where anyone can walk away at any time, many believe that a pre-dispute mediation clause is unnecessary. A pre-dispute mediation clause, however, is often extremely valuable to the parties since it ensures that they will at least come to the table and give the process a chance. If only given a chance, the statistical success rate for reaching settlements is extremely high. More than 85% of the commercial mediations conducted by the American Arbitration Association result in a settlement, generally with considerable savings in trial preparation. It is a generally accepted premise that mediation works. Many mediators and mediation agencies have observed that the most difficult part of the mediation process is to get the parties to maybe. In other words, to convince the disputing parties and their counsel to agree to try mediation in the first place. Though this may seem odd in light of the high success rate of mediation, there is some explanation for the hesitancy. Mediation is still an unfamiliar process to the uninitiated. During times of stress, which most people experience while involved in a dispute, individuals tend to react critically to the unfamiliar. The records of any mediation agency or private mediator are filled with cases indicating that parties or lawyers who are familiar with the benefits of mediation tend to use it repeatedly. Many people, even experienced lawyers, hesitate to suggest settlement discussions to the opponent. The one who blinks first in a dispute is considered hesitant and is often viewed as the person who holds the weakest hand. The parties to a dispute may feel that being the one to offer mediation may indicate fear or panic, and for that reason will avoid making any such suggestion. There are two possible solutions: a pre-dispute mediation clause or the use of an agency to bring the parties to the table. These two solutions can be combined to create a powerful tool to establish the right climate to fashion creative solutions to business problems. CAMCA, the Commercial Arbitration and Mediation Center for the Americas, was created by the leading arbitration institutions in Mexico, Canada, and the United States to fulfill this purpose. Information on CAMCA can be found at the American Arbitration Association's webpage. A pre-existing mediation clause, which requires the parties to meet and discuss the dispute in good faith in the presence of a trained mediator, will avoid any stigma, real or perceived, for suggesting mediation. Thus, rather than appearing to have a weak case, the suggesting party will merely be complying with the terms of the contract. A pre-existing mediation clause, or the use of an institution, allows the business executive or lawyer to fashion a process to meet the needs of the client, as well as the concerns of the others involved. The pre-dispute mediation clause is a sub-agreement contained within another agreement between the parties, such as a commercial or construction contract. The clause specifies that the parties will mediate their claims in the event that a dispute arises. The pre-dispute mediation clause, by definition, is drafted before a dispute has arisen. It can specify that the mediation will take place at any particular mediation organization, and if so, the rules of the organization will be incorporated into the agreement. A sample American Arbitration Association standard pre-dispute mediation clause reads quite simply: if a dispute arises out of or related to this contract or the breach thereof, the parties agree first to try in good faith to settle the dispute by mediation under the commercial mediation rules of the American Arbitration Association. Obviously, this approach should be taken only after counsel has reviewed the agency's rules and found them satisfactory. If the parties prefer not to incorporate the rules of an agency, or if the mediation agency does not provide specific rules, the pre-dispute mediation clause may be custom drafted in order to set forth the specific ground rules for the mediation. A pre-dispute clause will often also suggest other forms of alternative dispute resolution, such as arbitration, if mediation fails. After a dispute arises in a case where a pre-dispute mediation clause has been executed, specifying a mediation agency or mediator, it is necessary only to contact the agency or the agreed-upon mediator. It is good practice to provide mediators with a brief description of the nature of the dispute to allow the agency to suggest a list of appropriate mediators. The American Arbitration Association, for example, attempts to provide mediators with the appropriate subject matter expertise. I remember one opportunity we had to help international business people resolve a dispute over the construction of an industrial building. We selected as a mediator the executive vice president of an international engineering company who was well versed in business practices of the nationalities represented in the discussions. The matter was resolved to everyone's satisfaction. The agency will also most likely provide the parties with rules on how to conduct the mediation. If the parties are attempting to engage in mediation without the benefit of a pre-dispute clause, or if the agency or terms of the mediation have not yet been decided, it's important to draft a clear and enforceable mediation agreement. When the parties agree upon and retain a mediator, they must make sure that the appointed mediator understands and will adhere to the terms set forth in the mediation agreement. Often, the mediator will be a signatory to the mediation agreement or to a specific agreement setting forth the obligations of the mediator. If the parties choose to itemize the terms of their mediation agreement rather than incorporate the rules of an agency, certain key issues should be addressed. It is important to make the mediation agreement as complete and self-executing as possible. The following provisions should be included in the mediation agreement. The agreement should include the definition of what is meant by mediation, making clear that the mediator cannot order or force the parties. This is important because the mediator is not hired to tell the parties what to do. The extent of involvement of the mediator should be decided by the parties and, if possible, articulated in the agreement. Set forth the steps needed to begin the process. The agreement should be specific enough to be enforced and should identify the specific agency, if any, to be contacted. If no particular agency is listed, the agreement should specify how and when convening will occur. Set forth a method for the appointment of the mediator. The parties should agree on the qualifications of the mediator. Selecting the right mediator is one of the most important aspects of the mediation advocacy, not because there may be some advantage to be gained by selecting a mediator who has any particular philosophical point of view, but because mediation requires a highly developed level of skill and sophistication. The mediator should be knowledgeable about the negotiation and mediation process, and preferably have familiarity with the subject matter of the dispute. Most agencies will, if known, disclose the relationships between the mediator and the disputants, the counsel, and the parties. Counsel may wish to seek that information before selecting a mediator. Most agencies will meet with the lawyers and suggest the names of several experienced mediators for the parties to consider. The American Arbitration Association, for example, will also give a recommendation from among the suggested names based on the mediator's performance in similar situations. In certain situations, the parties will definitely want a mediator who specializes in the subject. Several appointing agencies maintain lists of trained, experienced mediators who have subject matter expertise. The rationale for this position is that a trained mediator who is also an expert in a subject will be able to more easily discover the weaknesses and strengths of the various positions of the disputants and help them to craft a remedy which is both rational and acceptable to all concerned. Set forth how the parties will proceed if a selected mediator is unable to perform. In drafting the agreement to mediate, parties sometimes designate in advance their mediator of choice. It is important to articulate some procedure to replace the mediator if, for some reason, this becomes necessary. Set forth a timetable to begin the mediation. The parties should agree on a timetable for scheduling the mediation sessions so that there is expeditious resolution of the dispute. Define the parameters of privacy. The parties may wish to agree on a format of the procedure, whether there will be private caucus sessions or only joint sessions. This, however, can also be left to the mediator's discretion. Set forth who should attend the mediation. The parties should also consider addressing, in the agreement to mediate, who should attend the mediation. Although it will be impossible to determine at the pre-dispute phase who might be involved in the dispute, the parties can agree on whether to limit the attendance and in what way. Mediation is most successful when the attendance at the sessions is limited to the parties, including the decision makers, their counsel, and the mediator. In such a case, the agreement should provide, for example, that only the parties and their representatives or experts may attend the mediation sessions, and that other persons may be present only with the consent of all of the parties and the mediator. The parties may also want to confirm the importance of each side bringing to the mediation party a decision maker with complete authority to resolve the dispute. Address the issue of confidentiality of the information given to the other party and to the mediator. In order for the mediator to perform his or her function, it is necessary that the parties feel free to disclose information without fear that such information, the position they take, or an admission they make for the purpose of settlement, might be disclosed in any subsequent proceeding. Any complete agreement to mediate should therefore include a confidentiality clause. The parties should decide whether and to what extent they wish to keep certain information confidential. For example, if they will be submitting pre-mediation briefs or memoranda to the mediator, they should determine whether those briefs will be exchanged with each other or submitted confidentially. The parties should also decide on the language of the confidentiality agreement with the mediator. Establish the steps needed to terminate a mediation. Although the odds are less than 1 in 5, it is possible that the mediation will be unsuccessful. The agreement may address the forum for dispute resolution in this eventuality. This is a good opportunity to specify any other means of alternative dispute resolution desired, such as arbitration. Otherwise, the dispute will likely end up in court. Allocate the costs of mediation. Any agreement to mediate would not be complete without a discussion of the allocation of the mediator's fees and the other incidental expenses of the process. Mediation agencies perform a number of useful tasks. They generally charge for their services, and these charges vary greatly from agency to agency. In most cases, not-for-profit agencies charge less than others. The lawyer is best advised to review the total cost of a service, including both the agency fee and the mediator's fee, when comparing the cost of various providers. Most providers will help bring the parties to the table. This is often referred to as process conciliation. The provider will work with the initiating party to educate the other party or parties about the benefits of the mediation process. Many mediation providers have trained staff to help in this education effort. Some agencies charge a fee for the service, others do not. The pre-dispute mediation clause is the wave of the future. It provides the parties with the mediation option without stigmatizing either side. Once the dispute arises, a successful mediation will most likely follow a well-drafted, clear mediation agreement. Thinking through these issues at the pre-dispute phase or during the early stages of the dispute can help avoid trouble down the road.
Very interesting. Thank you, Mr. Cooper. Let's begin the first question and answer session. We will try to answer as many questions as possible. Therefore, we ask that only one question be asked per phone call, and that these questions be as brief as possible. You may call the studio directly at the phone numbers or fax which now appear on your screen. We remind you to make your phone calls at a distance from the monitor to avoid feedback. The first question that we have is coming in from Sanyo de Norteamérica in Tijuana, Baja California.
Good morning. Question is, how are we going to adjust the mediation process when this process is developed in a multicultural environment where the expectations and idiosyncrasies are very important factors in said process?
Mr. Cooper, would you like to address that?
Well, I think that the mediation process is an extension of negotiations. And as we increasingly have cross-border and multicultural business relationships, we are going to be negotiating increasingly between our business cultures. And mediation, as an extension of the negotiation process, will develop. I don't expect that 10 years from now, cross-cultural mediation between Latin America and the United States will be what we expect it to be today. I think it's a living institution which will grow and change.
Thank you. The next question that we have is from the Asociación Interamericana de Mediación en la Universidad de Salvador, Buenos Aires, Argentina.
Good morning. The question we would like to pose here is, what do you attribute the fact that the bar associations are resisting to consider that mediation is a practice of law?
Judge Brennan, would you like to address that?
Okay. First of all, I'm not familiar with the fact of all bar associations resisting mediation. I know in our state, for instance, most of the lawyers in the Bar Association have embraced mediation, and there are even several lawyers who specialize in mediation. I do know there is a segment of the bar in our state who is concerned about mediation, and I think their concern stems from the fact that they worry that it may take away from their business and that they may not have the same number of cases to go to court. But by and large, those are the minority of the lawyers in our jurisdiction. We find out that most lawyers who embrace mediation enjoy practicing it. They find that their clients not only like this service, but again end up being more pleased than when they end up going to court or going through a more formalized process. So I hope that most bar associations benefit from our experience and see that in fact it is something to be embraced and nothing to be worried about.
Thank you. Go ahead.
The most popular bar association training program in Northern California was a program entitled Come Learn About Mediation Before Your Clients Educate You.
Thank you very much. The next question we have is from Bamer Indush, S.A.A., Participações, Empreendimentos, Curitiba, Brasil. Okay, now we're taking one from Cochabamba, Bolivia.
Buenos días.
Buenos días.
Deseo hacer la siguiente pregunta.
I would like to ask the following
En
question.
la práctica de la legislación,
When you
¿cuál
practice
es la
law,
diferencia
what is the difference
entre el proceso
between
de
the
arbitraje
arbitration
y
process
el proceso de mediación?
and the mediation process? Thank you.
Mr. Cooper, would you like to address that?
Sure. Arbitration is a forum substitution, substituting a private trier of fact, the arbitrator, for the court. Mediation is an extension of negotiations, a way for parties themselves to resolve a dispute. In arbitration, just as in litigation or the court process, the parties have given responsibility for resolving their dispute to a third party, either the court or the arbitrator. In mediation, the parties have kept the responsibility for resolving the dispute themselves.
And this is why in the courts we always try to encourage parties, at least initially, to explore mediation, because we find out when the parties themselves again reach their own resolution, they're usually more satisfied than when they have a third party come in and impose a decision upon them, and that's whether it's an arbitrator or a judge or a jury.
Thank you very much. Our next question is live. It is from la Universidad Nacional Autónoma de México, la Universidad Hispanoamericana en Coacalco, en el Estado de México, México.
Good morning. Do you think you have to adapt and revise the legislation of the different countries, of the contracting parties, in order to include mediation, or do you think this is going to be a private act, part of a private negotiation, a private deal or business deal?
Judge Brennan, do you understand that question?
Yes, as I understand the question, it has to do with whether legislation has to be revised in the various countries to allow for alternative dispute resolution. And in my opinion, I think that initially this is going to proceed privately through private contractual arrangements. And of course, as was pointed out by Mr. Cooper in his talk, you can include in any contractual negotiation a mediation or arbitration clause. And I don't believe that there are any laws that currently exist in any of the countries that would prohibit this. So although there may be legislation eventually, I think initially alternative dispute resolution, mostly mediation and arbitration, will come into effect through private contractual arrangements. And I don't see these arrangements as being prohibited by any country's laws, at least as far as I am aware.
Mr. Cooper?
I think that I would agree with Judge Brennan with respect to mediation. And in some senses, because mediation is a creature of the parties themselves, it may actually have benefit to not surround the process by too much statutory requirements. On the other hand, arbitration really flourishes best when the legislation supports the arbitration process, and many countries around the world still do not have modern arbitration acts that follow the UNCITRAL, the United Nations Commission on International Trade Law, model law on arbitration. And of course it's our hope that eventually all of the countries in the world will adopt UNCITRAL related arbitration statutes and therefore support the arbitration process.
Thank you. Our next question is live from KTV Comunicações LTDA in Rio de Janeiro, Brazil.
Very good morning. I would like to know what percentage of the judges and magistrates on an international level believe in mediation as an appropriate alternate dispute resolution vis-a-vis the formal proceedings.
Judge Brennan?
Okay. I'm sorry, I don't think I could give you an exact percentage of judges who get involved in international law who support mediation. All I can tell you is based on my own contacts with judges who have handled international disputes, and I think judges throughout this country are becoming much more educated to the process and much more in favor of that process. But I don't have any statistics to tell you how many actually support it. All I can tell you is that more judges become familiar with it, they become more supportive of the process.
Our next question, again, is live. It's from la Universidad Autónoma de Baja California en Ensenada, Baja California, Mexico.
Good morning. In what percentage does the time is time reduced between the formal proceedings and arbitration? How much time do you save? And on the other hand, about international conflicts, we always have ethnic conflicts and political conflicts. Do you think for these you can use also mediation or arbitration? And do you think who would be the ideal judges in these cases? What would be the intermediary parties?
Mr. Cooper, do you want to talk about the time saving to begin with?
Sure. The arbitration or mediation as well, but arbitration is the caller's question, is a creature of the contract of the parties, of the agreement between the parties to submit their dispute to an arbitration process. And therefore, they can make it as fast or as slow as they wish. Almost everywhere in our experience of more than 50,000 cases a year at the American Arbitration Association, the parties prefer to move the process along reasonably quickly. I can't compare arbitration throughout the world, but in the United States, arbitration is much, much faster than the court trials would be. In most of our large urban cities in the United States, it takes several years to bring a case to trial and to have a judgment rendered. The average length of time for a major commercial arbitration is 9 months from start to finish. So normally less than 1/3 of the time.
Judge Brennan, what about the issue of ethnicity and political issues? Are those subject to effective mediation or arbitration?
Well, as I stated when I was talking, I feel it's particularly important for whoever gets involved as the mediator or the arbitrator to have some understanding of the different cultures, the ethnicity involved, and of course there are beginning to arise lists being kept by various organizations of mediators who are not only trained in mediation but have understanding of different ethnicities, different cultures, and that is an important aspect, I believe, of mediating an international dispute. And I know the American Arbitration Association has such a list, and the U.S.-Mexico Conflict Resolution Center out of Las Cruces, New Mexico, is beginning to compile a list. So I think it's important to get mediators who have understanding of the various ethnicities. As far as, I don't know whether the question addressed actually mediating disputes involving political issues, and again, that would obviously be something difficult, but assuming you have an appropriate mediator, I think it is something that could be subject to mediation.
Thank you. The next question is again live from la Universidad Autónoma de Baja California Sur en La Paz, Baja California Sur, Mexico.
Good morning. Who selects the mediator, and do you specify in the contract and if you do not include a clause in the contract about mediation, what validity does it have when you are actually trying to apply it?
Mr. Cooper?
Let me answer the second half of the question first. Mediation, most disputes between parties are not resolved in litigation. Even most disputes which are filed in court are eventually settled before the judge makes a decision. And so mediation as a settlement technique between the parties has the same kind of validity as any settlement would have between the parties. As to how the mediators are selected, appointing agencies like the U.S.-Mexico Conflict Resolution Center or the American Arbitration Association maintain lists of mediators and make those available to the parties. Quite often, the parties will ask us